As most of you know, I summarize legal filings in the Delphi case as they come out. This video is just a summary of the legal filings by the defense and prosecution since my last Delphi live chat. February 14th, defendant's verified motion to preserve and produce specific evidence. It was 7 pages, filed by the defense. My summary is, on February 12th, 2025, defense attorney Andrew Baldwin met with inmate Reese Davis, who talked about Ron Logan's alleged confession. Davis stated he met both Kegan Kline and Ron Logan at Newcastle Prison. Logan confessed to being involved in the murders with 2 other people, but never said who they were, although he revealed details only the killer would know, according to Davis. March 2024, Kegan was placed near Davis, and Kegan asked if Ron Logan mentioned Kegan's name, and Davis began to realize that Kegan may have been one of the other 2 killers. Kegan began to reveal details of the murders that corroborated details Ron Logan told Davis that only the killers would know. These conversations continued until Richard Allen was found guilty, and Kegan was relieved he would no longer be a suspect. At least that's what Davis said. Kegan told Davis that Richard Allen was not the 3rd killer and was not involved. Kegan told Davis he knows Ron Logan from trading child abuse materials and sharing burner phones, and would meet every 3 to 6 months to show Logan how to use the phones. Continuing, the inmate Davis sent prosecutor Nick McClelland up to 8 letters before Rick's trial, detailing his conversations with Kegan and Ron Logan, and assumed McClelland was sharing them with the defense. Baldwin met with Davis on March 27, 2024, and learned, quote, very limited information, end quote, from Davis, who said to watch a videotaped interview from years earlier that Davis had done with police. On February 12, 2025, Davis said he did not provide details earlier because of the following. 1, he had not yet heard from Kegan, and 2, he was not sure if Richard Allen was the 3rd person involved and did not want to help Rick's defense if Rick was involved. On March 28, 2024, Baldwin emailed McClelland and also Stacey Diener asking for the video Davis referenced, but they ignored the request and never sent it or an explanation. The 8 letters Davis sent, quote, would contain multiple layers of exculpatory evidence which the defense could have used to further its investigation as to whether certain facts contained in those letters could be verified through crime scene photographs, digital data, and a variety of other means, end quote. But the prosecution never handed over those letters, so on February 12, 2025, Baldwin emailed McClelland and Steve Mullen, the prosecutor's investigator. Actually, Mullen recently quit that job, and he's going to go back to being the chief of Delphi Police because the last chief of police got in trouble. Moving along with this filing, McClelland's response was vague and did not indicate if they received the letters or sent to the defense. On February 13, 2025, Baldwin emailed again asking if McClelland received the Davis letters, but McClelland has not replied yet as of this February 14th filing. The defense looked and do not see the letters in discovery. The defense wants Judge Gull to order McClelland and law enforcement to preserve the letters and the video interview and hand them over to the defense. Last slide for this motion. The defense has a witness with admissible evidence that the prosecution received the letters from Davis in the months before Rick's trial. The defense had a constitutional right to know about those letters and conduct an investigation and depositions, present them at the summer 2024 hearings about the third-party motives and suspects, and used it for the trial strategy and the motion to correct errors. On February 24th of this year, Baldwin filed an addendum with an affidavit from the uncle of Davis stating he was asked to contact the Carroll County prosecutor to see if they received the letters from this inmate Davis. The uncle said a female in the prosecutor's office answered the phone and stated they received his letters and passed them on to the people in charge of the investigation of the Delphi murders. Also filed by the defense on February 14th, defendant's verified motion to strike state's response to motion to correct errors. This was 11 pages. My summary is, the prosecution violated a rule by not filing affidavits within 15 days. Attached is Brett Gibson's November 3rd, 2022 email stating he would not be Rick's attorney is based on facts outside the record and unsupported by affidavit or verification. McClelland stated the defense received the van video and Ron Logan information on January 30th, 2024, but he did not include an affidavit or verification for the supporting document. There was, however, a list of discovery that the prosecution sent to the defense on January 30th, 2024. McClelland stated Reese Davis The inmate who accused Ron Logan of giving a confession failed a polygraph, but the defense did not file any exhibit of a polygraph. I added, the defense filed an Exhibit 4B, that is Officer Hansard's notes, which included a page with numbers that may have been the results of the polygraph of Davis. McClelland stated Ron Logan told Davis he removed the phone battery from the girl's phone at the crime scene and left the phone behind and took girls' clothing and burned them, but nothing in the defense exhibits reference that, so it is based on facts outside the record and unsupported by affidavit and is a violation of Indiana rules. Davis said Ron Logan burned his clothes, not the girl's clothes. Nothing anywhere says Ron Logan took a phone battery, so McClelland is either making it up or has not shared that information with the defense. Continuing, McClelland stated no evidence placed Ron Logan at the scene of the murders, but that is based on facts outside the record and there is no affidavit. McClelland stated Sergeant Cecil was able to view photos of Libby's phone at the scene, but did not specify if Cecil actually viewed them. McClelland stated Cecil testified the log entry on Libby's phone about the headphone behavior could have been caused by dirt or water based on his experience, but Cecil based it on a Google search during a break in his testimony at the trial. The court, aka Judge Gull, might want to hold McClelland in direct criminal contempt for publicly filing crime scene photos the court ordered sealed at McClelland's request. So these were the 3 photos just of Libby's phone. There were no bodies in it. However, I can understand how Baldwin is bringing up this point that Gull agreed no crime scene photos should be released, and technically the phone photos are crime scene photos. Moving along. McClelland referenced the reasons the phone would not log water damage, but he is not an expert and attempts to testify as if he were one. There's an added quote, "This pleading is not his first attempt," end quote. Because all of the state's responses listed were based on facts outside the record and unsupported by affidavits, their entire response should be stricken from the record. McClelland repeatedly misstated the law. McClelland stated there did not need to be a hearing for the safekeeping order, but that is not true because Rick had a right to refuse the transfer because Lesenby only stated it was to protect Rick's personal safety. I went back to look at the safekeeping legal documents, and that is not true, what Baldwin just stated. This is a quote from one of those documents. Potential safety and security concerns exist not only involving the defendant, but also both jail facilities in Carroll and White counties cannot guarantee the safety or security of the defendant, staff, or facilities. So it's not just Rick's personal safety, but also the staff and facilities. Continuing, McClelland referenced the Chronic case, but Baldwin states he apparently is unacquainted with footnote 25. McClelland erroneously asserts a motion to correct errors only applies to newly discovered evidence. It provides for evidence outside the record. McClelland said the YouTube link of the van video was improper, but he knew it was also submitted on a thumb drive. It was posted to YouTube, quote, simply for the ease of viewing by the parties and the court, end quote. I added, and people who follow the case. McClelland knew or should have known Brad Weber's testimony that he arrived home about 2:30 p.m. before Libby's phone stopped moving at 2:32 was false, but did nothing to correct his testimony. Quote, a conviction must fall when the state, although not soliciting false evidence, allows it to go uncorrected when it appears, end quote. Lesenby's affidavit, at least twice, contradicts his testimony at the June 15, 2023 safekeeping hearing. In his affidavit, Lesenby said Richard Allen was transferred to White County because of overcrowding. But in June 2023, Lesenby said, quote, concerns of potential safety and security of our facility, end quote. Also in the affidavit from Lesenby, he said, Judge Diener at no time gave me legal advice on the motion for safekeeping. However, at the June 2023 hearing, Lesenby said, quote, I prepared a similar motion to this. Again, the wording was adjusted by the court, end quote. By the court, it means the Judge Diener. Next, Baldwin stated that Judge Diener violated judicial conduct rules by reviewing or drafting a document. Judge Gull should vacate Rick's entire conviction or hold a hearing to discuss this motion. The same day, February 14th, Judge Gull issued 4 orders. She denied without hearing all 4. including the defense's motion to correct errors and the motion to strike the state's response. Also, another motion for hearing by the defense. She stated, "No hearing is required, therefore it is denied." Moving along to number 3, motion to preserve specific evidence. Gull said the defendant did not cite any authority, statutory or case law, to support this motion. Judge Gull does not have the authority to order the state of Indiana, the prosecutor, labs, law enforcement, etc., to preserve said evidence and not destroy or lose said evidence. Not sure about that, but okay. Moving on to the final one. On January 20th, the defense filed a motion to correct abstract of judgment, which referenced December 23rd, 2024, when Gull issued an abstract of judgment and indicated there were no mental health concerns with Richard Allen. Yet at the trial, evidence was presented that Rick had significant mental health concerns. Providing accurate information on the abstract of judgment is critical to ensure the Department of Corrections is aware of Rick's mental health issues, so he will receive continuity of care, an appropriate placement, effective treatment and medication, etc. Gull denied it. Next, on February 18th, orders issued by Judge Gull. It was 4 pages long. My summary is, the requests for exhibits by the media were not specific enough, and there are many exhibits the court reporter is cataloging, and she is busy preparing the transcript. If the media makes more specific requests, the court will try to accommodate the request. I added this part here as a reminder. The evidence that NBC Dateline said they wanted as soon as possible, before the Dateline episode recently aired, were the 2 recorded police interviews with Rick, prison phone calls between Rick and his wife and his mother, and the 43-second cell phone video. I added here, I'm not sure how much more specific Judge Gull needs them to be. There were only 2 recorded police interviews, phone calls played in court between Rick and his family, and the most famous video everyone knows about. However, I do understand that it would be easier if the media requested specific exhibit numbers. Next up, on February 19th, filed by the defense, verified request for hearing on defendant's verified motion to preserve and produce specific evidence. This was 3 pages long. My summary, Carroll County local rule states, quote, "The state shall disclose to the defense any material or information within its possession or control that tends to negate the guilt of the accused as to the offenses charged or would tend to reduce the punishment of such offenses," end quote. The defense believes the state has materials that fall under that even before the trial. Baldwin referenced this other case, Pruitt versus State, quote, "Suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good or bad faith of the prosecution," end quote. The prosecutor has not replied to confirm the existence of letters or video of Reese Davis or if they were sent to the defense. Baldwin would like a hearing to discuss whether the prosecution suppressed exculpatory evidence and if the evidence was favorable to Richard Allen because it was exculpatory or impeaching, the state suppressed it willfully or inadvertently, or the evidence was material to an issue at trial. 9 days later, on February 28th, McClellan replied with his response to defense's motion to preserve and produce specific evidence. This was 12 pages long. McClellan reiterated what Judge Gull said on February 14th. There is no authority for the defense to request the evidence be preserved. Not all evidence from an investigation is discovery. Most of what Reese Davis told Baldwin was false, and Baldwin put that information in a public motion without verifying its truthfulness. The Department of Correction sent a list of all outgoing mail from Davis to the Carroll County Prosecutor's Office, which was attached as Exhibit 1. Davis sent 3 letters, not 8, like Baldwin had stated. They were dated October 4th, 15th, and 21st. McClellan erroneously wrote 2025 instead of 2024 about 8 or 9 times. The state was able to recover the October 4th and 21st letters and are attached as Exhibits 2 and 3, but they cannot find the October 15th letter. Oh, lordy. Add it to the list. These letters are not exculpatory for Richard Allen and therefore not evidence or discovery, and actually they accuse Richard Allen of committing the murders. The October 4th letter was titled Information on Kegan Kline and Richard Allen, which implicated Richard Allen as setting up the meeting with the girls and that he killed the youngest girl and moved the bodies. So that's considered inculpatory evidence since it's bad for Rick, not exculpatory. Continuing, in the October 21st letter, Davis stated that Logan, Klein, and Allen are responsible for the murders, and Baldwin is an ignorant lawyer who was, quote, hinting me to lie for him and his client, saying that I should know how it is, end quote. McClelland stated that the October 21st letter is an exhibit, but I could not find that quote in what was attached. So McClelland said the state cannot find the October 15th letter. James Winter is the uncle of Reese Davis, and he wrote an affidavit for Baldwin saying that he called the prosecutor's office around October 15th and 21st to see if they received the letters. McClelland said the information from Davis did not match the evidence at the scene, so the state thought the information from Davis was not credible. There is no evidence Kegan Kline and Ron Logan knew each other or shared child abuse materials. Kline denied the allegations by Davis. Davis did send letters to other attorneys. McClelland said Baldwin could have requested this information from the Department of Correction, but Baldwin filed his motion first. However, I wondered, would the Department of Correction even give it to an attorney like Baldwin, who is not representing Davis? I would imagine there'd be some problems trying to get that information. Final slide. Baldwin stated he interviewed Davis on March 27, 2024, but chose not to have him testify at any hearing or the trial. In the two letters from Davis, he does not match the statements Baldwin said he made to him. Davis did not say Allen is innocent. Evidence that states the defendant is guilty is not exculpatory and does not have to be given to the defense. There is no video interview of Davis in discovery or the state's possession. None of this is newly discovered evidence because the defense interviewed Davis and chose not to present it at trial. At the summer 2024 3 days of hearings, the defense did not meet their burden for Ron Logan as a third-party motive and suspect and did not present this as evidence from Davis. This motion seems to be another attempt by Baldwin to push a narrative to the public with very bold allegations, but he does not verify the information or present evidence to back up the statements. Finally, McClelland requested Judge Gull deny the defense's request for a hearing, which she already did. That's it for the latest updates. I will continue to summarize these legal filings, and maybe I'll do a live chat update sometime in March. Thanks for watching. Bye.